What if I told you that student loans might not be as permanent as you think? Most people believe that student debt is inescapable, but there are legal ways to challenge, discharge, or even eliminate your student loans. In this video, I'm going to be breaking down the laws that may allow you to discharge student loans, the difference between forgiveness and discharge, and essentially how to fight back against the lenders. So let's dive into it. But first things first, man, thank you guys for watching this video. Just to tell you a little bit about myself, man, I've been studying consumer law, debt discharge, debt loopholes, and federal lending regulations. And today I'm going to be revealing the truth about student loans and what they don't want you to know. Also, I'm going to be talking about things that they don't talk about. All right? I'm going to give you real and raw game. So make sure you guys are taking notes. Make sure you guys are paying attention. Make sure you guys stay tapped in. Okay? The question is, can you really discharge student loans? The answer to that question is yes. Okay? And essentially, most people get this aspect wrong. Okay? And we're about to be talking about that today. Now, make sure you like and subscribe to the video. Okay? Make sure you guys do that, because if you guys invest in me, I'll continue to invest in you. All right? We're about to hit 20K subscribers. So if you guys can subscribe, it's completely free. I would very much appreciate that. Also, like the video, okay? So we can push this on the algorithm and everybody can see information that people are scared to talk about, okay? So let's just talk about the difference between student loan forgiveness versus discharge. Now, let's just talk about the fact that they can forgive your loan because the debt is already discharged. So technically, a forgiveness is, in my opinion, is BS. But it is a strategy that you can utilize to your benefits, okay? So let's just talk about forgiveness. Forgiveness is when the government cancels parts of your loan balance, but only under specific programs. So when they say they're doing out loan forgiveness, it's a particular program that they're putting out that is more for, I would just say from my perspective, is more of a marketing tactic, okay? They get some type of benefit from it, and that pushes people to, I guess, pay their student loans if it's less, especially if it's people who keeps deferring them and things of that nature. I'm not 100% sure, so I won't talk too deep into that. That's just my theory, okay? Then we talk about discharge, which is one of the primary things that we talk about on this channel, an aspect of consumer law, where your loan is completely erased due to legal or financial circumstances. So many assume student loans can never be discharged, but that's not true, okay? Thing is, you can always, the aspect of discharging is transferring the obligation from one party to the next, okay? It's not putting you in a position where your debts are not going to be paid. It's essentially doing what the law says you can do. It's a right, all right? If you exercise the things that I'm about to talk about properly, then you too can be able to erase your student loan debt. Okay, now there's multiple ways to skin a cat. I've talked to many people. They have different strategies out there that they do, but I'm going to be talking about a couple things, not only from my perspective, but also from the perspective that we commonly know. Okay, so the first way to discharge your student loan is by filing bankruptcy. Now, I only tell people to file bankruptcy in a situation where they are in a dire situation, where they feel like they absolutely need to do it. I did a video on bankruptcy. I'll go ahead and link it right above somewhere. But always tell people to exercise as many strategies as possible and only do bankruptcy as a last resort. Okay? So yes, it's possible if you can prove a undue hardship under the Brunner test. And if you guys don't know anything about the Brunner test, so here are the factors under the Brunner test that essentially allows you to file for bankruptcy. It says here are the three factors the bankruptcy court will consider under the Brunner test. You can't maintain a minimum standard of living for yourself and your family is forced to repay your loans. That's one. Two, your current financial situation is unlikely to change during the repayment period. And three, you haven't tried to get out of paying your student loans and can demonstrate you made a good faith effort to repay them. So this is the Brunner test. I don't want to spend too much time on this because I don't want people to, get to this point of the video and say, well, damn, Nicholas is going to tell me about filing for bankruptcy. Once again, I only recommend filing bankruptcy if you have done everything in your power to not only pay the loan, but also at the same time discharge the debt. Okay. The next thing that you can do is you can essentially use a borrower's defense to repayment. So if your school misled you, you essentially can be eligible for a loan cancellation. So the misleading aspect of they didn't give you the proper disclosures, or they didn't give you information that was essential to the loan. Hence the things that we talk about, where the loan originated, if they actually fund the loan, and things in that nature, if they actually risked their money or giving you a loan. These are some of the things that you can challenge them on a basis and premise of the laws and regulatory laws that are put in place. And if you do this properly, then and they're unable to prove that they didn't mislead you, then you may be eligible for discharge. Okay. Now, once again, I gotta start talking about some legal terms, but this is not legal advice. Do your due diligence. You dig me? Everything that I'm about to talk about right now, make sure you cross-reference, make sure you go online and review it yourself. Okay. I tell people this all the time. Look, I can go and study and do this information, but it is important for you to go tap in yourself and gather the knowledge yourself. Even if I tell you how to express it, how to say it, unless you truly look at it for yourself, you probably won't execute and you probably won't believe it. Okay. So you can essentially defend against a student loan. Now, the third thing is if your school closed down. Okay. If your school shut down, your loans may be eligible for discharge. So if the school is no more, you can fight the fact that there's nobody to pay back. Okay. Unless the loan came from a different channel. But if the school is shut down, then essentially you're eligible for discharge. Then there's total and permanent disability, TPD discharge. If there's medical conditions, you can essentially qualify for a loan cancellation. So if you are on some type of total or permanent disability, then you may be eligible for discharge as well. Okay. And then another thing is false certification discharge. If your school falsified enrollment eligibility, you may not owe the debt. Okay. So the question would be, can you discharge student loans like other debts? Okay. And the answer will fall under the things that I'm about to talk about. Now, first things first, here's some key laws that can challenge student loans. You dig me? Hold on. So the first place we're going to start with is 12 U.S.C. 95A, under public policy and debt discharge. And essentially it says that your any and all debt is already paid under public policy. Okay. So when you look at this, it says during a time of war, the president may, through any agency that he may designate and under such rules and regulations that as he may prescribe, investigate, regulate, prohibit any transactions in foreign exchange, transfers of credit or payments between, by, through, or any banking institution, and the importing, exporting, hoarding, melting, and earmarking of gold or silver coin or bullion currencies or securities, and investigate, regulate, direct, compel, nullify, void, prevent, or prohibit any acquisition of holding, withholding, use, transfer, withdrawal, transportation, importation, exportation of, dealing in, exercising any right, power, or privilege with respect to or transactions involving any property in which a foreign country or national thereof has any interest. We'll just go ahead and skip through all of this fluff right here and go straight to any payment, conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States as otherwise directed pursuant to section of any rule, regulation, instruction, direction issued hereunder shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation of the person making the same. So long story short, 12 U.S.C. 95A, which goes along with Trading with the Enemy Act, essentially discharges all debts. Okay, or it affirms that all debts are paid under this public policy. It goes hand in hand with 31 U.S.C. 5118. It goes hand in hand with 18 U.S.C. 8. And these are some of the laws you can go and check for yourself. But ultimately, all loan debt is discharged under public policy. Okay. Then we tap into 15 USC 1601, which is the Truth in Lending Act, which gives you the ability to challenge the company on, I'm back, I had a phone call. It challenges the company on the proper disclosures that should be given to you as a consumer in a consumer credit transaction. And a student loan is a consumer credit transaction that falls under the Truth in Lending Act. Okay. Now, under the congressional findings, one of the most essential things that I like to talk about is the informed use of credit. Okay. It is the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to, compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. The whole point of me bringing this up is because the key word is uninformed use, okay, and informed use. So you have a right to ask them for specific details and disclosures, and if they do not provide it, then they are considered violating your Truth in Lending Act rights, okay? And then we dive into the definitions, which it breaks down the definition of credit. It breaks down the definition of creditor. So if a bank says that they are a creditor, then in some way, shape, or form, they are misleading you. Okay, they're actually misrepresenting themselves as a creditor. When you look at this subsection, and it says that credit means the right granted by a creditor to a debtor to defer payment of debt, to incur debt, and defers payment. And it also says that the term creditor refers to only a person who both regularly extends in connection with loans, sales of property, services, or otherwise consumer credit, which is payable by agreement in more than 4 installments. So the point of me bringing this up is, I highlighted person because the definition of person means a natural person or an organization. Then we tap into, okay, what is an organization? An organization means a corporation, government, governmental subdivision or agency, trust, estate, partnership, cooperative, or association. So long story short, Bank of America or those entities that claim they are creditors cannot be a creditor unless they was a natural person, okay? Then we tap into things like the Federal Reserve Act that affirms that we actually create the credit using our signatures, and they monetize our signatures to create credit, okay? So that's a most important aspect that has to be covered, because you can challenge them on this information. You can ask them to provide proof that they are the original creditor. And if they were to lie to you and say that they are the original creditor, then they'll be violating your rights. Then we tap into 15 USC 1692G, where the question that you can ask under this subsection is, can the lender prove that the debt is valid and enforceable? Well, only way something can be valid and enforceable is if they provide the details of the debt, not only on the aspect of, if you agreed to it, but they have to prove that there is a debt to be owed. They have to prove that they actually have risked any money. They have to prove that there was a loan given out. Okay? They have to prove that they have properly disclosed documentation to you under the Truth in Lending Act. Okay? They have to prove that they legally own the debt. Okay? That the amount claimed is accurate. Okay? And if they cannot validate the debt, they must cease collection efforts. And that's the whole point of 15 USC 1692G, or the entire subsection of the FDCPA, which is debt collection practices. If they try to collect on a debt that they did not prove as valid, prove that they have ownership, then by law, they cannot collect on the debt. They must forfeit collection. All right? Part of that is challenging on whether or not they are the holder in due course under UCC 3-305. Whereas if someone who claims that you owe them money is not the holder in due course of the original note or of the obligation, then they cannot come after you for the debt. But also at the same time, how do you affirm that they are the holder in due course? You ask the question, was my loan securitized or sold to investors? If so, who legally owns the debt? So you're asking them, hey, do you own the debt? Or does somebody that you sold it to loan own the debt? If so, then by law, if you guys cannot prove that you own the debt or prove that you're the holder in due course, then you cannot legally collect. You don't have legal standing to enforce your debt. Okay? So there are more laws that I can talk about. We can talk about the Federal Reserve Act, Section 16. We could talk about the modern money mechanics and where money comes from. But the whole thing that I want to break down is the aspect of how to properly challenge them. Okay? Now, if you got into this point, you're a real one. Okay? Make sure to like the video if you haven't already. We are dropping more bangers as you guys continue to invest in me. Okay? Also, at the same time, subscribe if you haven't already. Okay? I think we have a good about, I think 98% of people watch my videos and do not subscribe. Okay? And it's crazy because I'm dropping that game. And it will help me if you guys would subscribe. It's completely free. Now, let's talk about how to take action and challenge student loan debt. Okay? Step 1, you want to request loan validation from your servicer. You want to ask them under 15 U.S.C. 1692G to demand proof that the loan is valid and enforceable and properly owned. You have a right to ask them these things. Okay? They cannot deny you for you to ask them of these things. All right? The second thing you want to do is, if you feel like your school misled you, especially when you challenge them on the Truth in Lending Act and challenge them on through debt validation and they do not provide certain documentation and you feel like you have been misled, you can apply for a borrower's defense discharge directly through the Department of Education. Okay? The Department of Education will allow you to you can not only challenge this through a legal process, but you can challenge this strictly through the government. Okay? Step 3, right? You can also dispute the inaccurate credit reporting. Okay? If your loan is in default but improperly documented, or they didn't provide certain evidence and things in that nature that proves the default, proves that the loan was valid, then you can challenge it under the FCRA. We didn't talk about 15 U.S.C. 1681, but essentially a lot of times the biggest thing that hurts us is when they put it on our credit report. So if you're able to overcome that, then you are in an even better position than not. Okay, so you can essentially remove anything off your credit report, from student loans to debt collections to charge-offs and things of that nature, because the FCRA is a separate battle from debts. Okay, you're challenging the accuracy of the information, and in order for something to be proved accurate, they have to have all this documentation. Okay, then if it gets to a point where they are ignoring your reach out, they're ignoring your letters and things in that nature. I did a video on what to do if you are being ignored by a debt collector for your negotiable instruments. I'll link that video right here somewhere. If they refuse to validate your loan, this is when you want to escalate it to the CFPB. You want to escalate it to the Federal Trade Commission. You want to escalate it to the state attorney's general office. You fill out a form, and also at the same time they are still trying to collect and ignore your letters and responses, then you have grounds to go through those regulatory agencies. Okay? Then if you get to a point where the regulatory agencies aren't enough, then you intend to sue the company for their non-compliance. Okay, yes, you can sue them on whether the debt is valid, but that's not what you would sue them for. You would sue them for their non-compliance, because by law, if you ask for certain details and they do not provide it, then they are in the wrong. Okay? Now, there are aspects where there are people who say, well, the judge will always side with them and things in that nature. Yes, there are cases where the judge will side with the banks, but that's typically in a case where you are not playing the offense. You are not challenging the loan servicer first. You are waiting for them to default, and you are trying to basically use this argument in court. But if you have substantial evidence of you trying to perform on a contract, you trying to dispute this, and they aren't doing what they're supposed to do by the Truth in Lending Act, by the FDCPA, by the UCC, then they are putting themselves in an unlawful position, and that is a no-no. Okay? There's a other aspect of, if that doesn't work, you can essentially take them to federal court. Okay, now this is not legal advice, but if this is something that you feel like you genuinely need to get a result for, take them to federal court and get a jury. Okay, if you get a jury, then now it's the jury, it's not just the judge making the choices. Now there's an actual jury that can listen to your case and go based off of all the evidence and the pertinent facts and say, well, you know what? This person is maneuvering this way. Also, at the same time, when you start to make things like this public, all right, or threaten to make these things public, these are other things that the banks do not want to happen, okay? So usually, if you are going to continue, if you end up getting to a position where you lose in court, then appeal it and consistently appeal it. Keep appealing it, because it costs them. Yes, it may be costly, and I've seen this in the comment section, but it will cost way more for the companies to keep going to court for something that they know they got paid for already. Okay, they're going to lose all the money that they got or they're trying to collect by keep going back and forth with you. So if you keep being persistent and you keep challenging them on these things, then what's going to happen is they are eventually going to settle with you. Okay, and again, no promises, but if you are persistent, then you can get the results. Okay, so I want you guys to understand that here's a key takeaway: that student loans may not be as untouchable as you think. If a lender cannot prove the debt is valid, legally owned, or properly disclosed, you may have grounds to challenge repayment. So, just to wrap up, now that you guys know the truth about student loans and how to legally challenge them, all right, I also didn't talk about, hey, if all this fails, do what you gotta do. You know what I mean? But now that you guys know how to do this, okay, go out there, take action, read more information on these things. Check out my links down below. I have a step-by-step discharging guide through to complete that guide. It's only $47. Templates, letters, resources are down there. It's only $47. You dig me? Check it out. I have a step-by-step instruction. Okay. If you guys tap in, then you guys are going to be able to learn these concepts, and it's going to bring more clarity to my YouTube videos. Another thing, if you want to work with me one-on-one, I have a link down in the description where you can apply for my mentorship. My mentorship, once again, is not strictly about debt discharge and things in that nature. It's primarily for helping you build your credit so that you can be able to secure funding from the banks. One of the primary things that people struggle with is having bad credit, okay? And if you have debt, I wouldn't recommend applying. I would tell you to tap in with the complete debt guide. It's only $47. Gather the knowledge, learn so that you can be able to take action and remove your debt, whether you're gonna go through the process or whether you're gonna pay it, okay? But if you are coming to me and you say, hey, I want to fix my credit, I want to build to a 700 plus credit score, I want to be able to fund my business, I want to be able to tap into entrepreneurship, apply for my mentorship down below. The link is in the description. And if you feel like, hey, look, man, this is something I cannot do on my own, I don't even want to learn it, I'm going through a lawsuit right now, tap in with SoloSuit. The link will be in the description as well. And then lastly, if you want to connect with me on a more consistent basis, I post daily on YouTube. Yes, on YouTube, but I'm on Instagram on a daily basis. Tap in with me on Instagram at biz.nick. The link will be in the description as well. But other than that, man, make sure you guys like, comment, and subscribe. Okay? Comment discharge if you got this far. And lastly, man, have you guys ever tried challenging a student loan? If you have, let me know your experience in the comment section down below. But other than that, I love you guys. I got to get ready for this meeting, and I'll see you next time.